My name is Michael Young, and I'm a lawyer who handles contested estates in Texas. A common question that I receive is, if I'm a beneficiary of an estate, do I need a lawyer? And the short answer is no, you are not required to have your own lawyer. The executor or administrator of the estate will be required to obtain a lawyer. The courts require it because they're acting in a fiduciary capacity. But there are several reasons why a beneficiary might want to consider hiring their own lawyer. The first, and this is a point of some confusion, is that the lawyer representing the executor or the administrator is not representing the beneficiaries. And I get these calls all the time from people complaining that I'm a beneficiary and my brother, who's the executor, his lawyer won't return my calls or won't help me or tells me that I need to get my own lawyer. And that's almost always the case because lawyers who represent uh, executors or administrators are careful not to provide any legal guidance or to protect the interests of beneficiaries. They're simply there to guide and protect the executor or the administrator. And also, most estates in Texas are independent, which means the executor acts on their own. And an independent administrator basically acts on their own without asking or obtaining court approval. They're on their own out there, which means that unless somebody complains to the judge, they can do almost what they want. And so, if you're a beneficiary and you believe you're not being treated fairly by the executor, they're not distributing the assets, or they're not following the terms of the will. And I get calls all the time where the executor says, I really don't care what the will says. I'm not going to sell that property and distribute the proceeds until I decide I want to. Various forms of that. Or they just stop answering questions and complain, well, you're causing me trouble, and that's not what mommy or daddy wanted. Don't be asking me questions. Those are terrible attitudes for an executive or administrator to take, but it happens. Well, the way to usually resolve that, and it's typically not that expensive, is simply to hire an attorney who makes a notice of an appearance in the case so the executor or the administrator and their lawyer knows that the beneficiary or multiple beneficiaries have hired a lawyer to protect their interests. In my experience, that alone will keep the executor or administrator honest. If not, then you can hire a lawyer to go even further, to bring claims or to demand an accounting or various tools that Texas law provides to rein in a wayward executor, to hold them accountable. And even in an independent administration, then the court can act. If a beneficiary hires a lawyer and complains and asks for an accounting and asks for why, after several years, the assets have not been distributed. There are various remedies if you do hire a lawyer. And in that case, paying a lawyer may be a small price to pay, maybe a drop in the bucket to the amount of assets that are at issue.